I'm Andy Panko, owner of 10 in Financial. Welcome to Retirement Planning Demystified. This video will explain the basics of what you need to know about estate planning. But before we start, remember this video is only general explanations and education. It's not specific tax, legal, or investment advice. Before considering acting on anything you see in this video, first consult with your tax, legal, or investment advisor. This disclosure is especially important for this video. I'm not an attorney, nor do I try to play one on YouTube. Furthermore, a lot of the document names and functions I'm about to describe may differ state to state. This is especially true if you live in a community property state. So in putting in place or updating your estate plan, be sure to work with a duly licensed estate planning attorney. Many people think an estate plan is simply having a will, which is a document that dictates what you want to happen with your dependents and assets after you die. While having a will is important, it's only one of multiple pieces of a complete estate plan. Estate planning not only addresses what happens after you die, but also addresses many important matters while you're still alive. For example, what happens if you develop dementia and can no longer make legal or financial decisions for yourself? Or what if you develop a major medical condition and are literally unable to communicate your healthcare wishes to your doctor? A proper estate plan should include, at a minimum, at least 4 documents. First is a last will and testament, which is more commonly known as a will. It states your wishes of what you'd like to happen to your belongings after you die. Your will should contain as much detail as possible about what assets you have and to whom you'd like to leave them. Furthermore, if you have minor children or other dependents, your will should clearly express who you'd like to be responsible for them, acting as their guardian or custodian, after you pass. Because if you don't decide, the state will appoint who they feel would be best. And that person may not be the same person you would have chosen. Next is a power of attorney. This details who you give authority to make legal or financial decisions on your behalf if you're no longer capable of doing so or are otherwise not available to make a decision when necessary. A power of attorney can be limited to a specific activity or can be general to allow for all necessary decision making. Additionally, a power of attorney can be durable so that it's effective immediately upon execution, or it can be springing so that it only comes into effect upon the occurrence of some specified event, such as your mental incapacitation. You should also have an advanced medical or healthcare directive. This is also sometimes known as a medical power of attorney or healthcare proxy. Whereas a power of attorney document just mentioned grants decision-making authority for legal and financial matters, an advanced medical directive grants decision-making authority specifically for healthcare matters. This document expresses who you appoint to make medical decisions on your behalf if you're no longer able to do so. It's important to note this does not typically address matters relating to end-of-life decision-making. Instead, that power is conveyed through the next document type, which is a living will. This contains written instructions to medical providers regarding what treatment or support you want or don't want in end-of-life conditions such as terminal illness or a permanent vegetative state. As an example, a living will can instruct doctors to not put you on life support or not resuscitate you. It's important to know that all these documents can be changed at any time, so don't be concerned about making a decision or appointing a person who you may later want to change because the documents can always be revised. With that in mind, it's actually a good idea to revisit your estate documents every few years. People may come and go in your life, so you want to make sure to keep appointees up to date. Or your views and opinions of people may change over time, so you may want to leave more or less to certain people. And keeping estate documents current is especially important when you have minor children or other dependents who will need legal supervision after you're gone. Raising a child or caring for a dependent is an incredibly important responsibility. With that in mind, you want to make sure you're still comfortable with the guardians you previously appointed. While the documents I just mentioned are all critically important, they alone don't complete your estate plan. There are certain assets that pass to your heirs without going through a will. For such assets, it's vitally important to properly designate beneficiaries or structure the ownership of the asset accordingly. The most common example of these types of assets are things like life insurance. Upon your death, your life insurance policy will pay the benefit amount to whomever you designate as the policy's beneficiary. You don't have to, and typically shouldn't, state the policy's payee in your will. Your beneficiary designation directly in your policy is the cleanest and most efficient way to make sure your benefit ultimately passes to your intended beneficiary. Next are retirement accounts like 401ks, 403bs, IRAs, and pension plans. Like life insurance, upon your death, these accounts will pass to whomever you designate as their beneficiaries. Again, you generally shouldn't attempt to define retirement account beneficiaries in your will. These accounts all have their own beneficiary forms to fill out, completely separate from your will. The main difference between assets like life insurance and retirement accounts versus other assets such as houses, cars, or collectibles is that life insurance and retirement accounts pass upon your death by contract as opposed to by probate. By contract simply means those asset types have their own beneficiary designation forms and processes that stay outside of probate. Probate is a process by which the state court system will oversee the administration of your estate upon your death. In a nutshell, when you die, your will be submitted to the state. The state will then review and hopefully accept it. The state will then govern over the process of doling out your assets and establishing guardianship for your minor children in accordance with the instructions in your will. The probate process can be long and tedious, and the state doesn't necessarily have to accept your will and may override certain of its instructions or terms. This means your wishes may not ultimately be acted upon. When assets like life insurance or retirement accounts pass by contract, they completely circumvent the probate process. This means the assets pass quicker and with less chance of your wishes getting challenged after your death. Another word for these assets is non-probate assets because they stay outside of probate. Also, because the probate process goes through the court system, your will and estate administration process is ultimately public record. Now, that may or may not be an issue for you, but when an asset passes by contract, that all stays outside of the public eye. There's some other asset types that would still normally go through probate, but you can help ensure the transfer to certain people without having to go through your will. You can do this by what's called account titling, which is the name of the process of designating the ownership type of certain assets. For example, if you're married and own a house with your spouse, you can own the house under a form of ownership known as joint tenants with rights of survivorship. This means you both equally own the property, and if one of you die, the other automatically assumes ownership of the whole thing. You don't need a will or a court to decide whether or not your spouse gets to keep ownership and use of the property. You can also title ownership that way for non-retirement financial accounts, such as checking and brokerage accounts. Even if you're not married, you may be able to structure ownership of certain assets to avoid probate. For example, you may be able to set up a bank or brokerage account as being payable on death, otherwise known as POD, or transfer on death, otherwise known as TOD. As the name of these ownership titlings imply, the account will pay or transfer on your death to a designated beneficiary. Trust can also be used as an estate planning tool to help ensure your assets go where you decide without the courts getting involved and without the probate process. Trust can get incredibly complex, and the intricacies of trust are outside the scope of this video. But at a high level, a trust is basically a big bucket. It's its own legal entity that can take ownership of whatever you put in it. And because the trust is legally distinct from you, it can live on indefinitely. When you die, your trust still stays there intact. So, one way to efficiently pass your assets and keep them out of probate is to create a trust while you're alive and transfer ownership of certain assets to the trust. That way, the trust will technically own them, not you. So when you die, they're no longer your assets to have to pass on. The trust will continue to own them. Therefore, the trust will stay out of your will, out of the court system, and out of probate. There's a lot more to trust than this. For example, you need to set up a trust agreement that dictates what's supposed to happen to the assets in the trust, and who's supposed to get those assets and when. And you'll also have to appoint a trustee to oversee the trust, and that person needs to be knowledgeable, trustworthy, and capable of properly administering the trust for the foreseeable future. Again, trust can get very technical and very complicated very quickly. For now, just know that trust can be used to help simplify your estate planning. Well, that's it for estate planning basics. There's a lot more to estate planning than what was discussed here. As an example, this video didn't touch on any of the strategies for minimizing taxes through the estate planning process. That will be a whole video on its own. This video is just to give an introduction to the documents, terms, and tools used in estate planning. I hope you enjoyed it. If you haven't already, subscribe to this channel so you can be the first to know when new videos are posted. And don't forget to subscribe to my monthly newsletter, Retirement Planning Insights, which provides informative retirement planning tips and info. Also, Be sure to join my free Facebook group, Taxes and Retirement, where you can get answers to all your retirement-related tax questions. Thanks for watching. I'll see you soon.